Unleashing innovation, safeguarding your creative legacy. In a world where ideas dance like sparks in the vast expanse of imagination, there lies a realm where innovation takes center stage. Intellectual property. Imagine a symphony of creativity, each note composed with dedication and brilliance, waiting to be heard, seen, and celebrated. The canvas of ideas picture this, you the master of your own creation, weaving dreams into reality. Intellectual property is your canvas, and your ideas are the strokes that paint a masterpiece, from groundbreaking inventions to soul-stirring art. This canvas holds the potential to change the world.
As you embark on your creative journey, remember the importance of protection, the shield that guards your intellectual treasures. Patents stand as sentinels, shielding your innovation from imitation. Trademark etch your brand into the mint of the world, a beacon of trust and quality. Copyright weave a cloak around your artistic expression. Trademark etch your brand into the mint of the world, a beacon of trust and quality. Copyright weave a cloak around your artistic expression, ensuring your work remembered and
The
respected.
symphony of exclusive rights. Imagine a world where your brilliance is acknowledged and your hard work is not just admired but also respected. Intellectual property grants you exclusive rights, paving the way for recognition, reward, and the satisfaction of knowing that your ideas are truly yours. Nurturing the creative ecosystem. Intellectual property isn't just about protecting your own, it's about fostering a creative ecosystem where ideas flourish and innovation becomes a collective anthem. By respecting the intellectual property of others, we contribute to a world where every creator is empowered to leave an indelible mark.
A legacy of innovation. As the curtain falls on this motivational video, envision the legacy you're creating, an intricate tapestry woven with threads of activity and creativity, protected by the pillars of intellectual property. Your ideas, your legacy, a testament to the power of innovation. So, fellow creator, embrace the journey, protect your vision, and let the world witness the brilliance that unfolds when creativity meets intellectual property. The stage is set, the script is written, and the spotlights await. Your masterpiece is ready to shine.
What is intellectual property? It refers to creation of mind in commerce like inventions, literary and artistic works, design, symbols, name, and image. So, intellectual property is protected by the law, by copyright, patent, trademarks, which enable people to earn recognition or financial benefits from what they create or invent. So, the intellectual property system aims to foster an environment in which creativity and innovation can flourish. Let's define the term copyright. Copyright is a legal term used to describe the rights that creators have over their literary and artistic works. Works covered by the copyright range from book, music, painting, sculpture, film, computer program, ads, maps, and technical drawing. Copyright protection extends only to expression and not to ideas, procedures, method of operation, or mathematical concept as such. There are two types of right under copyright. First is economic right, which allow the right owner to derive financial reward from the use of their works by others. Second is the moral right, which protect the non-economic interests of the author. Most copyright state that the right owner has the economic right to authorize or prevent certain uses in relation to work or to receive remuneration for the uses of their work. The economic rights owner of a work can prohibit or authorize its production in various forms such as printed publication or sound recording, its public performance, such as in a play or musical work, its recording, for example, in the form of compact discs or DVDs, its broadcasting by radio cable or satellite, its translation into other language, and its adaptation searched by a novel into a film scenery. Example of widely recognized moral rights include the right to claim authorship of a work and the right to oppose changes to a work that could harm the author's reputation. In majority of countries, and according to the Berne Convention, copyright protection is obtained automatically without the need for registration or other formalities. Most countries have a system in place to allow for voluntary registration of works, such as voluntary registration system can help to solve disputes over ownership or creation, as well as facilitates financial transaction sales and the assignment and transfer of rights. In the Philippines, copyright protection to artistic literary and derivative works lasts during the lifetime of the authors plus 50 years after the author's death. Now, let's proceed to patent. A patent is an exclusive right granted for an invention which is a product or a process that provides a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. In principle, the patent owner has the exclusive right to prevent or stop others from commercially exploiting the patented invention. In other words, patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without the patent. Owner's consent. Patents are territorial rights. In general, the exclusive rights are only applicable in the country or region in which patent has been filed and granted in accordance with the law of the country or region. The protection is granted for a limited period of generally 20 years from the filing of the application. Now, let's proceed to trademark. A trademark is a sign of capable of distinguishing the goods or service of one enterprise from those of other enterprises. A word or combination of words, letter, and numerals can be perfectly constitute trademark, but trademarks may be consist of drawing, symbols, three-dimensional features such as the shape and packaging of the goods, non-visible signs such as sounds or fragrance, or color shades used as a distinguished features. At the national or regional trademark protection can be obtained registration by filing an application for registration with a national or regional office and paying the required fees at the international level. You have two options. Either you can file a trademark application with a trademark office of each country in which you are seeking protection, or you can use Word Intellectually Property Organization or WIPO's Madrid system in principle. A trademark registration will confer an exclusive right to the use of the registration trademark. This implies that the trademark can be exclusively used by its own owner or licensed to another party. For use in return, for payment, trademark rights are private rights and protection is enforced through courts. The term of trademark registration can be vary, but it's usually 10 years. It can be renewed indefinitely on payment or additional fees. Methods of computer software protection. Copyright, patents, and trademarks. Intellectual property for software is computer code or software protected by law under either a copyright, trademark, trade secret, or software patent. When you treat your software as an intellectual property, you have the more control over the who get to use it and how it gets to the public. Otherwise, people might use it without permission, and you'll lose the chance to get paid when people your use your software. When you hold the copyright software code, you can make copies of your own software code, sell or give away the code, make a derivative work, which is a second software that uses a lot of original code, and post the code somewhere or otherwise displays it. You need a patent to protect a process like the function of a software, including system, function, and solution of computer program. Utility protects what the software does. Design protects and the decorative part of your software. You can protect your software as a trade secret. A trade secret is a information you or your company has that other people don't have. This information in business and it gives you a leg up over your competition. Application of the principle of fair use of proprietary information in digital format. The, the intellectual property laws specifies certain limitation or exemption to copyright. This is called fair use. When you wish to copy an entire work or a portion of it, even even when the copyright holder fails to give his or her permission, fair use may be invoked in certain occasions. The rationale of fair use is to guarantee some breathing space for a new expression within the confines of copyright law. In other words, if copyright holders have complete control of their works, information may be considered and restrained from ever reaching a wider audience. There are four factors considered for fair use. One is the purpose and character of your use. Second is the nature of the copyright work. Third, the amount and substantially of the portion taken. And fourth, last, is the effect of the use upon the potential market. Free Software Movement and the Open Space Initiative. The Free Software Movement was started to support the GNU project, which was started in 1983. The GNU project was a multi-programmer effort to try and create a free version of operating system Unix. The Free Software Movement is philosophically and code of ethics for software and hardware products. It can give the right to share, use, and even build upon a work as well as protect user against the threat of copyright infringement with the condition that this user abide by the condition specified by the owners or holder of the copyright.